Good evening, everybody, and welcome to our panel tonight, Cross-Border Prosecutions. My name is Andres Torres. I'm an Assistant District Attorney in Manhattan, assigned to the Office of the Special Narcotics Prosecutor. And it's a great pleasure and a great honor for me to be the moderator for tonight's conversation. We're really very, very fortunate to have a great group of panelists tonight. And before I introduce each one of them, I wanted to take a quick minute to thank our sponsors. First, the Inter-American Affairs Committee of the New York City Bar Association is the sponsor of tonight's event, along with several co-sponsors, including the Criminal Advocacy Committee, the Foreign and Comparative Law Committee, the White Collar Crime Committee, and the Women in Legal Profession Committee. So thank you all very much. And with that, I'm going to introduce each one of our distinguished panelists. Daniel Alonso is a partner in the New York City office of Buckley, LLP. Prior to entering the private sector, he served in the United States Attorney's Office for the Eastern District of New York for nearly a decade, including 3 years as chief of the criminal division, and was later the chief assistant district attorney in the Manhattan District Attorney's Office. Ludmila Groch is a partner at the law firm of Lefosse Abogados in Brazil and is a member of the firm's white collar crime, anti-corruption, compliance, and regulatory investigations practice. Next, we have Andres Harfuch, who is a public defender and associate professor of law at the University of Buenos Aires and vice president of the Argentine Association for Trials by Jury. Andres has played a leading role in bringing jury trials to Argentina. Ilan Katz is a founding partner of the Mexican law firm Katz and Gudino. Ilan has more than 20 years of experience as a litigator. His practice in Mexico is both local and federal. Maximo Langer holds the David G. Price and Dallas P. Price Chair in Law at UCLA School of Law, and is a leading authority on domestic, comparative, and international criminal law and procedure. He is a native of Argentina. Marco Magdic began his career as a prosecutor in Santiago, Chile, was the former head of the Organized Crime Bureau of Chile's Ministry of Interior, and is a senior consultant on public security, organized crime, and justice reform programs in countries throughout the hemisphere. So with those introductions, just quickly before we begin, I wanted to just give a basic overview of the format for tonight's conversation. We're going to begin with an introduction by Professor Langer, and after that, we have pre-selected 5 areas that we would like to focus on this evening. Each panelist will have approximately 10 minutes or so to discuss their particular area. Now, within that 10 minutes span, others will also be able to offer their comments or perspectives on the different issues. If a panelist speaks for the full 10 minutes, then we'll just move over to the next panelist. But if a panelist speaks, for example, for 5 minutes, then there'll be 5 minutes for commentary. And then, or if not, we'll just move on to the next panelist. Again, we know that all of these areas, all of the topics could be the subject of their own individual panel. But I think the point of tonight's conversation is to give an overview of some of the important characteristics of practice and legal traditions in these Latin American countries, and see how they are reforming and how certain changes are happening that are quite interesting. So having said that, I also just want to say I apologize if I have to interrupt you. If you go beyond those 10 minutes, I certainly want to hear everything that you have to say, but I want to move it along. And also towards the end, if there's time, we'll also have members of the audience can submit questions on the chat or using the Q&A function. So with that, I'm going to kick off the conversation. I'd like to ask Maximo to please provide an overview of some of the general differences between the inquisitory system of law and the adversarial system of law that we use here in the United States, making reference perhaps to how most Latin American countries have begun for now about 2 decades or so to adopt adversarial practices in an effort to tackle perceived deficiencies in their criminal justice system. With that, I turn it over to Maximo. Thank you.
Okay, thank you very much. Well, good afternoon first, or good evening, or good morning, wherever you are, in this multi-zone events, right, that we are now used to in these COVID times. First of all, let me thank Andres Torres and the Inter-American Committee of the New York City Bar Association and all the different institutions that are sponsoring this event. It's a pleasure for me to be here today talking to you and in company of such distinguished panelists. So in terms of introduction to inquisitorial systems and adversarial systems,
Maximo, I think you turned off your volume accidentally.
okay, but you heard the beginning, right? So I don't know how this happened, but okay, perfect. So in terms of the question of adversarial and inquisitorial systems in Latin America, it is always tricky and hard to talk about Latin America as a whole. Let me start with that, just represented in this, among our panelists, right? The situation in Brazil, in Colombia, in Chile, and in Argentina have been very differently, historically speaking, right? And have been very differently also in the last a few years. So what I'm going to do is a little bit of a generalization that then the different speakers can comment on, right, and explain some differences with their own jurisdictions. If we concentrate in, let's leave Brazil aside for a moment. And if we concentrate in, because it has its own trajectory, right, with its code of 1941, and the whole independence process in Brazil played out differently also in the 19th century. But if we concentrate in Spanish-speaking countries of Latin America, essentially in most of the jurisdictions of the region, criminal proceedings were written from beginning to end. What do I mean by this? Well, in the United States, we are used to trial by jury. If there is not a trial by jury, there is a bench trial, but cases are supposed to be adjudicated at a hearing, right? In which, the parties may present their cases, and at which then the jury would make a decision, would issue a verdict, right? Or the judge, if we are talking about a bench trial. There was not such a thing in most Latin American countries, Spanish-speaking countries, until the last 3 decades. The proceedings were written in the sense that were more like administrative proceedings, if you want, right? The case would be compiled or in a file, and that file, right, that would be the different documents of the file would be gathered, and then there would be an adjudication of the case by a professional judge at the end of the case, right? So that was, for instance, more or less the system in most jurisdictions in Argentina. It was a system more or less in Chile. It was more or less a system in Colombia, with caveats we could discuss. I'm happy to be corrected here. So that was one sense in which these proceedings were inquisitorial, if you want, right? And so one of the things that happened in the last 30 years in Latin America, maybe starting with some of the reforms in a couple of Argentinian provinces, province of Tucumán, province of Córdoba, 1991, could be considered the first reforms in that regard. Guatemala, 1992, 1994, as a follow-up. El Salvador, also, mid-1990s. Costa Rica, same idea. Chile started, introduced this between 2000 and 2005. Colombia, 2004, right? Criminal Procedure Code of Colombia in 2004. Argentina is a federal country, so we are still transitioning to that in a number of ways, right? But though most of the countries in the region, most jurisdictions in the region, if not all of them, really introduce oral and public trials as a way to adjudicate criminal cases. So that's one thing. Some of these jurisdictions also introduce juries, right? And I'm sure Andres Harfuch is going to talk about this. But so oral and public trials, one thing. Second way in which these proceedings were inquisitorial is that most of the countries of the region, not all of them, Colombia, for instance, was already different that way since the constitutional reform in Colombia from 1991. But most countries in the region had an investigating judge who was in charge of investigating the case, looking for both inculpatory evidence and exculpatory evidence. That was a system in Chile, that was a system in Argentina, and that was a system in most Spanish-speaking countries in the region. That system was replaced in terms of the pretrial investigation phase by a regulation under which the prosecutor is now the one who is in charge of investigating the case. The police work in the investigation of the case too, but in theory, at least under the supervision of the prosecutor. And in some countries, though not in all of them, in some jurisdictions, though not all in all of them, the defense may also be able to do its own investigation like it happens in the United States, right? And so the introduction of this regulation radically changed the pretrial phase and the investigative phase of criminal cases in the region. Together with that, they introduced a number of reforms to kind of facilitate, if you want, the work of prosecutors and the investigation of cases. For instance, before these reforms, in many countries in the region, the rule of compulsory prosecution prevailed, meaning this is a rule that we find, for instance, in Germany, we find it in Italy. In Italy, it's even a constitutional principle, Article 112 of the Italian Constitution. But the idea of the rule of compulsory prosecution is that if authorities know about or learn about the possible commission of a crime, at least during their work, they have the duty to then initiate a criminal case. Right? In the United States, we don't have such a regulation, right? One of the characteristics of the United States, of all jurisdictions in the United States, I would say, is that there is a principle of broad prosecutorial discretion. In Latin America, the opposite principle prevailed for a long time. This wave of reforms of the last 30 years or so have changed that by introducing what in the region is called the opportunity principle. This is taken from German terminology, section 153 et sequitur of the German Criminal Procedure Code. That the idea here essentially is that in most countries, at least, the idea is that, yes, the rule is still compulsory prosecution, at least for serious crimes, but there are a number of grounds that prosecutors may invoke in order to dismiss criminal cases or not to file charges in the first place. Such as, for instance, the crime is not serious enough, the defendant may be helping the investigation, there may be multiple crimes, and there are other possible grounds. Another characteristic or another change in the region has been the introduction of plea bargaining or equivalent institutions. That's something that we did not have in the region 30 years ago. And today it's all over the place. Brazil is more complicated. The talk today is not about plea bargaining, but I'm sure that Ms. Groch is going to illustrate us about and teach us about that. But the point is that together with these oral and public trials, then the plea bargaining or something equivalent has been introduced all over the region. Again, maybe with one exception, but essentially all over the region as a way to adjudicate criminal cases. Other reforms have been reforms, for instance, to give a non-punitive response to criminal cases. So diversion mechanisms, right, what would be called diversion mechanisms in the United States have been adopted all over the region, right? I mean, with different names and different forms, but basically enabling the adjudication or dealing with a case. Dealing with a case without having to take the case to trial and without having to end the case with a criminal conviction, right? You know, if defendant meets a number of conditions, requirements that are set, then the case may get dismissed. There are also mediation, ADR type of mechanisms in many places for defendants and victims to get together, right, and kind of reach some sort of agreement about the case without again entering a criminal conviction. So those are some of the changes that we find all over the region. One very important change in this regard has been then that the prosecutors have acquired a central role, right, in the investigation and prosecution of criminal cases in the region, right, in a way that in most places, again, Colombia was different since 1991. Mexico was different actually since the time of the Mexican Revolution, but in most places in Latin America that was not the case. We had these investigating judges, right? And now prosecutors have taken this new role in leading criminal cases. So I think I'm going to stop there and turn it over to the next speaker so that we can save time for questions, comments, or further conversation. Thank you so much.
Thank you, Maximo. And yeah, just I'm gonna, before I turn it over to Ilan, just to emphasize just how really massive these changes have been, and how really admirable it's been for so many countries to reform their systems in such a deep and profound way. And this really has been a sea change over the last 30 years over so many, in so many countries. So with that, I want to now ask Ilan to start to perhaps address how people are charged in Mexico. So as all of us who practice in criminal law know that really one of the most consequential decisions that can be made within any criminal justice system is the decision to charge somebody with a crime. And few decisions carry so much weight. So maybe Ilan, if you could walk us through how charging decisions are made in Mexico, who ultimately has the power to make those decisions in Mexico, what safeguards exist for those who are accused, and so forth. Thank you.
Sure, Andres, and again, thanks a lot for inviting me to this illustrious panel. It's a pleasure to be with such great characters from our profession from all over the globe. I think that basically there's two areas where we are vastly different in charging, and I'd like to start just by
Did we
Looks
lost
like
Ilan?
the results that I have is that in the 90. I'm sorry, can you see me now?
you
Can you see me
froze.
now?
You were just about to start. If you could just, there were two areas. You were just about to, but
Yeah, sorry about that. There are two areas where I wanted to say that are really where I think the differences are in our systems, and I'd like to start at the end, the conclusion, and then go backwards. In the United States, the conviction rate, I think, is up around 90-something%. In Mexico, the conviction rate is 5%. And that has a lot to do with the way that cases are brought to trial. In Mexico, when a victim
Ilan, you froze again.
Yep. Ilan,
wants,
can you hear us? Just give Ilan just a couple more.
yes,
Okay. Sorry. Yeah, you just broke up again. You were just about you were talking about how the conviction rate in Mexico is about 5% in comparison with a much higher conviction rate in the United States, and you were about to
Yes. As I took off my camera to see if that helps because I'm out of the office. So I hope this makes things better. Anyway, so I think that has a lot to do with the way that cases are brought to trial. In the United States, the prosecutor is the sole person who can decide which cases will be prosecuted and which will not. In Mexico, any victim of a crime can go before the prosecutor's office and file a criminal claim. And then he has to prove before the prosecutor's office that he has enough evidence for that claim to go to trial. Then, and only then, will the prosecutor decide if that case has any merit or not. And the prosecutor can, during this process, which is known as the carpeta de investigación or the investigation file, can even ask the person who is being accused of the crime to come forth and present evidence. Once that is done, if there is enough evidence for the case to go to trial, then the prosecutor will go before the judge and ask for a hearing where the defense will hear the accusation against him and the case will start in the trial phase. Can you hear me well, Andres? Thanks. So if the judge hears the evidence and he believes that there is enough evidence for the case to go to trial, he will initiate a trial with a formal vinculation to trial, which is the act by which a person is put to trial in Mexico. But a trial won't begin. What will begin is a complementary phase where evidence will still be brought to trial, which is usually around 3 to 6 months. Once that evidence is brought to trial, there will be a phase where that evidence will be discussed. And then finally, there will be a trial, which is the third phase during this period, which is known as the oral trial, where that evidence will be presented, and finally it will be sentenced. And that can be appealed. And after the appeal of that sentencing, an amparo trial can be held forth to see the merits of the trial, to see if any constitutional rights had not been violated during that trial. So it's a lot of processes. It's a lot of filters for a case to actually go to trial and for a conviction rate to happen. But this gives anybody the chance to go before the prosecutor and have the prosecutor act sort of like a judge to value the merits of the claim and see if that case will go to trial eventually. Now, this is very important because in most crimes, which are not homicide, rape, physical crimes, the most or organized crime statutes, if the victim of the crime does not go before the authorities in a timely fashion, then the case cannot proceed or the statute will lapse. So it's very important to bear this in mind. Now, I think that this is very important to explain the difference in the conviction rate, but also how the prosecutors act in a certain fashion to see if a case will have merit or not, but to give access to justice to any victim of a crime. The other factor, the other area where I think it's very important to differentiate the way that cases are charged in Mexico and cases are charged in the United States has a lot to do with what we call in Mexico concurso de delitos, or in the Spanish-speaking world. And I'll give you an example. If a person is brought to trial for, let's say, a fraud in the United States, then he will also be brought to trial for the forgery of the documents which were part of the fraud. So he will have a wire fraud charge, a forgery fraud, a forgery charge, and a fraud charge. Or in a rape case where a person beats his victim in order to rape them, he will have an assault and battery charge and then a rape charge. In Mexico, and in most of the of Latin countries that have this system, you will see that any act which is part of the typical description of the crime, which, for example, in rape is the use of violence to copulate. Any act which is that violence in itself will not be charged separately as long as it is part of the actions that lead to this charge. And this is important for the following reason. If you see in Latin American countries that a fraud case will have a maximum charge of, let's say, 11 years average, then you will only have a charge that will go for 11 years. But in the United States, if you get a charge for fraud and they add on every other crime that then you can have somebody doing maybe 20 years for fraud. So I think these two are very, very different aspects in our systems. And I think I'll leave it there and ask any questions or any comments. And I'm sorry I'm having trouble with my internet. It's very embarrassing to have stalled you on my technological difficulties.
No problem, Ilan. Believe me, we understand it in this in the world of Zoom and whatnot. Thank you for that. Dan, maybe this is a perfect time for you to jump in. Ilan spoke about really the a number of things, but spoke about the power of the prosecutor in ultimately determining charges and whether or not to move a case forward. Perhaps you could speak from your vantage point as a former prosecutor and compare how it works here. And you have the advantage of having worked both as a state and federal prosecutor. Thank you.
Yeah, thanks for having me. And it's very, very interesting to compare it. It's very much like apples and oranges. I thought that, and if you want me to do this now, I thought that it would be useful to talk about the U.S. investigative system so that we can understand particularly the grand jury system, which is unknown in Latin America. It obviously comes to us from the English legal system, and we've kind of ramped it up on steroids. I mean, grand juries exist in all 50 U.S. states. By the way, this is to talk about the U.S. investigative system is really a backdrop to what we're talking about with you guys, right? I mean, it's really a compare and contrast. So I'm going to try to keep it short because I think I may be most useful in trying to contrast what some of the other folks say when people have questions. But I did, I did bring just a couple of slides which I think might be useful to to show the point. Can you see the you see that there? Are you able to see my my screen? Yes? Okay, I can't hear you. Huh?
Yes, we can.
Okay, good. Great. So so just to very briefly, so U.S. investigations are not done obviously by investigative judges like in an inquisitorial system. They're done obviously by police officers, but the prosecutor does in a sense control the investigation in the way that that the other folks were saying, but really the prosecutor doesn't have the authority to charge in large parts of our system, to charge somebody for a serious crime, a felony, without the approval of a grand jury. So it's worth understanding what a grand jury is. I have this map here, which just tells you where in the United States grand juries are active. The answer is they're active in all 50 states, but in 23 of the states, only 23 of the states, is it mandatory to have an indictment by a grand jury before a prosecutor can proceed. That includes some of the very important states like New York and Texas. And when I say important, I don't mean to diss other states. I mean a lot of legal cases come out of those states, but not all. California, most importantly, uses preliminary hearings instead of grand juries generally in order to charge felonies. All of the states, the other 25 other states can, the prosecutor can use a grand jury to charge if they want. And then in 2 of the states, the grand jury uses its investigative function only. So what do I mean by that? What is a grand jury? Its makeup varies from state to state, and I won't bore you. By the way, the federal system very famously does use the grand jury. It's enshrined in the 5th Amendment. But what the grand jury does, whether it's 23 people, as is true in the federal system and others, or sometimes just one person, what a typical grand jury does is 2 different things. One is it's a check on the prosecutor. There's no, there's no initial check by a judge. There may be a later check, but there's no initial check by a judge. The grand jury decides whether the prosecutor has enough evidence to go forward with a felony charge. And that's just the standard of probable cause, much lower than proof beyond a reasonable doubt. But it's the grand jury that has to make the decision in addition to the prosecutor. The other thing the grand jury does is, remember I said 2 states only use it for investigative purposes. The grand jury is the primary method in most of our jurisdictions by which prosecutors investigate criminal cases. And what's very useful for the prosecutor is that lots of different bodies can compel evidence. Some in civil enforcement in the United States and other countries, a single lawyer can just compel somebody by subpoena to come and give a deposition. What's different about the grand jury is that the grand jury has this tradition of secrecy, and it's very, very important, very, very severe, punished by criminal charges if you violate that secrecy of the grand jury. And the purpose of that is multiple. Most importantly, it's to protect people from the reputational damage of an investigation that might not result in a charge. But also, very importantly, is you can compel witnesses who don't want to be there to testify. And in theory, at least, if the secrecy is working, other people won't find out. And they won't find out what they say. They won't find out that they were there. And what is very, very important about that is in some cases like organized crime, violent gangs, public corruption, there's a lot of obstruction of justice going on, people trying to influence witnesses. So the grand jury has this way of having witnesses testify in a secret proceeding that none of them, except interestingly, the witness, is allowed to divulge. So the grand jurors can't say who was there, the prosecutor can't say who was there, the stenographer can't say who was there, the witness doesn't get a lawyer. It is literally questioning in secret. And that is, believe it or not, a very good way to get to the truth in the United States, because the witness doesn't know what the case is about. They don't have access to la carpeta, as we heard. Nobody gets to read the file. They just have to answer questions. And if they don't, they are subject to the penalty of perjury. They can be prosecuted for obstruction of justice. If they don't cooperate, they can be prosecuted or held in contempt. So it's very, very serious and very broad. There are lots of different rules for secrecy and exceptions about secrecy. I won't go through them. Just know that they exist. So that's really the main way that we investigate. And what's useful, I think, for today's discussion, particularly what we heard from Ilan, is, and I've done some work in Mexico, and I know about this. There's not a lot of formality to the system of grand jury investigation and prosecutorial investigation in the United States. If the prosecutor has the resources, and by and large, the US Department of Justice, the federal prosecutors tend to have them, and then other state prosecutors, by and large, some of them do and some of them don't. But when the prosecutor has the resources, the prosecutor and the grand jury get to decide what to investigate, even if no complaint has been made. So there doesn't have to be a victim or a formal complainant. The grand jury famously is allowed to investigate just to make sure a crime has not been committed. And sometimes grand juries don't even just investigate crimes. The New York State Constitution, for example, allows grand juries to investigate public malfeasance that doesn't necessarily rise to the level of a crime. So there's a lot of very broad things that a grand jury can do, and US prosecutors tend not to be bound in their charging decisions and in their investigative decisions by the kind of formalism that we see in some Latin American countries and under codes, whether they are the old inquisitorial codes or even the newer codes that are around. We heard about plea bargaining. I'm happy to talk about more of that because it has not been implemented anywhere like our system that I'm aware in Latin America. It's different, it's broader. There is a lot of discretion in the prosecutor. So I'll leave it at that, but I think there's room for a lot of comparison here. So thank you very much. Let me stop sharing my screen. Great.
Thanks, Dan. I don't know if anybody wants to jump in, has any question for Dan specifically about the grand juries. Now there'll be more discussion later. We also have discussion about plea bargaining in Brazil and how it works in Brazil. But Dan, I just wanted to, and maybe you touched on it a little bit already, but maybe you could just discuss a little bit about kind of the unique power that the prosecutor has within the grand jury because it's kind of a mixed role where not only presenting evidence but also determining legality.
Yeah, the prosecutor in general, is not a judge, but has a quasi-judicial role. The prosecutor has a function at the charging stage to decide whether there is enough evidence to go forward. Different prosecutors use different standards, and I won't get into the ethical standard right now. At a bare minimum, it has to be probable cause. But the prosecutor, in that sense, is behaving in a quasi-judicial function. And with the grand jury, it's very much a very similar thing. The role of the prosecutor vis-a-vis the grand jury is technically just the legal advisor. So the prosecutor is essentially the lawyer for the grand jury. Counsel to the grand jury is obligated to instruct the grand jury on the legal standards that they have to use in deciding whether or not to charge somebody. But in practice, it's a much stronger role. The prosecutor issues the subpoenas, decides what documents and other evidence the grand jury is going to seek, decides who to compel. The grand jury can have a say depending on the jurisdiction, but the prosecutor really does control the show, so to speak.
Thank you, Dan. And with this, the discussion about kind of the power of the prosecutor, both in the United States, and Maximo has discussed it as well in his remarks, as well as Ilan. I thought now I'd like to turn it over to Marco and ask him, Marco, you've worked throughout Latin America for now several years, advising countries reforming their criminal justice systems. And I think one commonality is that there has been an increase that the prosecutors throughout the region under these reforms, the adversarial system, certain aspects of the adversarial system are giving more power to prosecutors. Describe kind of what you have seen and from your experience, and I know that you've worked quite a bit in Colombia. You and I worked on a matter in Colombia just recently. If you could just describe that, discuss your experience, and any country specific references would be.
Yes, thank you very much, Andres. Well, first of all, my apologies if I make, because I'm sure I will make some mistake in English. It's not my native language. Even Spanish is not my native language, but I will try to do my best. I think first to answer your question, Andres, yes, the public prosecutor has much more power than in the past. And in sometimes the answer it's very logical. It's because the public prosecutor as institution is in most of the cases new. But just to understand that and the implication about the way how different system is developing in the region, in the Latin American region in particular, because I want to exclude the Caribbean region, maybe with the exception of Dominican Republic, that is more Latin American system way. I need to make some small introduction, and I'm very lucky that Maximo, thank you very much, Maximo, already do a lot of that work. So in general speaking, with major or minor differences, it's possible to see in Latin America, and please take in mind always these differences, that is, we cannot compare and analyze all the countries in 10 minutes. We have this inquisitorial system that it's amazing. You in the past, maybe 10, 15 years ago, 20 years, no more than that, you can face in a criminal court, an investigative judge, the same judge who is investigating you, he is controlling himself or herself, saying if you will go to the preventive custody or not. And as an investigative judge, and with this power of judgment, of course, there were no control of this activity. In some countries, we have also next to this investigative judge, a trial judge, but they are still the same part of the same institution. So it was a system that, in my opinion, affects in a very, very bad way the human rights, not only of defendant, but also of victims. In most of the country, the institution of public prosecutor as a person in charge of investigation or a person in charge to prosecute in front of the court was just an exception in most of the part. The confession in the region was one of the main evidence that the prosecutor, if you have prosecutor or investigators, like it. The victim was mostly an instrument for this kind of proceedings, not a subject of rights, but it was treated generally, in my opinion, as an instrument. A lot of formality, rituality, we still have that, but much more or less with in the last 10, 15 years. And I think that the pandemic helped us a lot with that, to fight that. The preventive custody was almost the way how the system was taking the decision of the crimes. It was the general rule. We still have some system where the situation is still in the same way, but we can face some differences today. The public defender office, and I hope that Ludmila can explain us the system in Brazil, but the public defender office as institution was recent creation. Just an example, in Ecuador, 10 years ago, Ecuador has 4 public defenders, attorneys in criminal cases, 4, and the rest of the defense was provided by law school clinic systems or programs, nothing at formal or state level. And we don't have also, and this is important for your question, Andres, public prosecutor criminal policy. There was no criminal prosecution policy at all. And it's logical because the judges work at like an island and don't reflect the criteria of any kind of institution like the judicial branch in that aspect. Maybe one of the exceptions, and Maximo already mentioned some of that, we can see something in Córdoba, a province in Argentina, or Costa Rica in the 70s, and in Córdoba in the 40s, but was just a small exception. So most of the problem, and you will realize why I'm touching this point right now, was that we understand as a region that this is a problem in way how the system is fighting crime, but also was considered as a human rights issue. So most of the criminal procedural reform in the region was promoted as a human rights challenge, more than an investigative needs, okay? So this is why in most of the countries, the countries created the public prosecutor office as an institution, what will be the Attorney General office, for example, in US, or the prosecutor office itself. But when they created institution, they created in most of the countries separately from the figure of the Attorney General. So you have the Attorney General or Minister of Justice in Latin American countries that is part of the executive branch, and he is in charge of justice policy, sometimes of prison services, but the prosecution, investigation of crimes was delegated to generally a new body called Public Prosecutor Office, Public General Office, Public Ministry. We have different ways how you can call it in the region, and I want to mention some particularities about that in the next minutes. So after the creation of this institution, they eliminated most of the country the figure of the investigative judges. Maybe one of the exceptions, and Maximo can give us more detail after that, will be some of the Argentinian provinces, and maybe at federal level in some particular cases. But in general, in the region, we don't see anymore an investigative judges. It was replaced by the Public Prosecutor Office. And then what they created was it calls like a guarantee judge or a safeguard judge. It's a particular judge that's just in charge to control the respect of rights of the defendant or the victims during the investigation stage. But once you feel the prosecution or the accusation, I want to go to trial, then you have another kind of court of composed generally in the region by 3 professional judges with no jury system also in general. So when they built the prosecutor office, they start thinking about, okay, will the prosecutor just go to the court to prosecute, to litigate, or we want to give the prosecutor more powers in order to direct and control the investigation from the very, very beginning. In my opinion, again, since most of Latin American countries were passing through regimes under dictators, they were very afraid to give too much power to the police in order to direct the investigation, because in the previous system they have this judge who is in charge of investigation, and then you have the police officers in charge to execute the orders of the investigative judge. But now with the public prosecutor office, this was a huge discussion. And most of the countries, I think I see just one singularity, maybe in Nicaragua, that where in the region you can realize that the prosecutor is the person who is not only in charge to prosecute, to go in front of the court, but the prosecutor is in charge to direct the investigation from the very beginning. So with some less exception, the police has no autonomy to do the work in the way how you can realize in the American or maybe Canadian system, okay? So the prosecutor has this huge power over the investigation. And the problem is, again, the implementation, because you may be having in one country 50,000 police officers and you have just 1,000 prosecutors. And then you have prosecutors with 2,000 cases each one. And of course that this will affect the way how the prosecutor are investigating. But this is the way how the system is built. And very linked to that is the position of the institute of the public prosecutor office. As I mentioned you, the public prosecutor was created as a new, different, separated branch of the government. So you can realize in most of Latin American countries, the executive branch with the president on the head, the judicial branch with the president of Supreme Court, the Congress or the legislative branch, and then you have the prosecutor, plus a fourth power of the state of a country. 100% on most of the cases autonomous, maybe with some exception, like for example Dominican Republic, it's still named just with the president without the intervention of the Congress. In Costa Rica is very autonomous, but from the other side the prosecutor office is a part of the judicial branch, so it's very unique system. And of course we have Nicaragua and Venezuela, that doesn't matter how the law is ruled, the way how the government apply the law and the system, you cannot expect an independent prosecutor office. A few years ago, and I think that Ilan or can, for example, give us some examples about that. Mexico also has this PGR, like the Attorney General office, that wasn't 100% independent. Right today, they change the system. So another aspect that is important to mention, Andres, is that if you start reading literature, or if you want to make some kind of surveys or send questionnaire to different countries, and this is the problem that the international organization usually have, is to understand that the way how the public prosecutor office called in different countries is different. But to make it even worse, the way how you call it in one country, this name exists in another, but means another thing completely different. So just an example. In most of the countries, public prosecutor, public ministry, or attorney general, it's almost the same as a concept, with the separation always from the Ministry of Justice, okay? But then in the Colombia, if you say public ministry, it's a complete different institution. It's not the same as prosecutor office, in the same way as in El Salvador. And in Colombia, if you say, for example, attorney general will be PGR, in the same way as in Guatemala, it's also another institution. And none of those institutions are part as a public prosecutor office of the government. So usually when the different systems or international organization calls to the prosecutor, make surveys, for example, for some countries, say, give me information of your government way of prosecution, the answer is given by the government Ministry of Justice and not the public prosecutor. So the image that you obtain is not the one that you're looking for, probably. I think that we can mention Colombia as one of the systems with the most unique power of prosecutor office. If we want to find a prosecutor office with more legal powers or ability, is maybe Colombia. I don't know if in a practical way this is good for them, but this is how the things are. In Colombia, the prosecutor office, the prosecutor can order different kind of investigative measures without a previous judge authorization. So again, in the rest of the continent or the region, you need to, if you want, for example, to see something, if you need to search, to retain correspondence, intercept telephone communications, you need to ask a prior authorization to this called guarantee of safeguard judges. But in Colombia, the prosecutor office must always have a previous authorization, with the exception of registration, retention of correspondence, search of houses, of locals or facilities, seizures are interceptation of telecommunication in all kinds of ways. So in that case, the prosecutor can proceed by their own, and after they take the measure, 36 hours later, they just at that moment they need to ask. It's not authorization. In that moment, will be like a kind of validation of their measure. So in a practical way, it seems that they have a lot of power. For me, I would rather prefer other system because I can have a huge investigation, a very good one, and if I make a telephone interception, for example, or I seize some assets that are critical and obtain evidence from that assets, for example, like computers. And after that, after this 36 hour, the judge, because of the very good defendant work, attorney defendant work, decide that this way of the way how I proceed as a prosecutor was against the rule of law, then I will lose all the evidence, all the investigation. I will start from zero. So I would rather prefer the other system. There's a lot of other examples that I can give you. I would rather prefer to leave that for the final, for the questions. But let me give you just an example how this difference about what is the prosecutor office in Latin America can imply. There is a meeting, for example, it's a meeting from the Organization of American States. It's a meeting traditionally existed maybe 20, 30 years, called the General Meeting of the Minister of Justice and Attorney General of the Americas. And whenever they have these meetings together, and was organized in the beginning by US and by Canada, the Attorney General present in the meeting start discussing issues regarding prosecution and organized crime and different kind of issues regarding prosecution. But considering the name of the meeting, of the Attorney General meeting on Minister of Justice, it was almost impossible to find in that meetings a public prosecutor offices. So it takes to the authorities more than 20 years to realize that they need to change the name, just to understand that there is a completely new way of investigate, to prosecute cases in the Americas. So now the meeting is called Meeting of the Ministers of Justice, other ministries, prosecutor, and the Attorney Generals of the Americas. So this is just an example how different are we. Thank you very much, Andres.
Marco, the complexities of bringing all these countries together, right? And I must say, in prosecuting cases and working with prosecutors in Colombia, it is very interesting to see kind of the wide authority that prosecutors have, for example, to order wiretaps and then have those reviewed by judges at a later stage. With that, we're going to now move on to Ludmila. Before Ludmila begins, I just want to say, if people in the audience have questions, please feel free to use the Q&A section to write your questions, or the chat, and hopefully we'll have some time to address some of those questions once our two other speakers are finished. But Ludmila, so there's been a lot of talk about trials and public trials and juries and prosecutors and all the rest. And, you know, and Dan actually touched on it a little bit. Really, what we haven't talked about is plea bargaining. And plea bargaining is such a critical and central part of any criminal practice here in the United States, but it's something that's very new in Brazil. So could you please discuss how plea bargaining works in Brazil, why it was introduced as a measure, as a reform measure in the Brazilian criminal justice system, and any observations you have about whether or not it's been effective, or to what extent. I understand that plea bargaining was really crucial in the car wash investigation that made international headlines. But with that, I'll turn it over to you. Thank you.
Thank you, Andres. I'd like to thank New York City Bar for this invitation here. It's a pleasure to be with all of you, my colleagues. And I think that it is very important to know that Maximo, in the beginning, when he was explaining the systems in Latin America, said, oh, except for Brazil, I think we can talk about the other Spain languages or countries different from Brazil, because really I think that Brazil is changing, just like the way Latin America is changing, considering the changing from the inquisitorial system to adversarial system, but it's in Brazil, the changes, they never come in a very organized way. We change a little piece of the system each time without making a complete questioning about the whole system and changing the other parts and the effects that these little changes they make. For example, I think we were talking about plea bargaining, for example. It is a very great example from that, because if you think that until 2014 it was impossible, it was mandatory for the public prosecutor to prosecute if he thought that a crime has been committed. So it was mandatory for them to prosecute. So it was impossible to propose any kind of deal here in Brazil. Of course, we had some exceptions for misdemeanors, and it was kind of a plea bargaining before 2014, but it was just for misdemeanors, not for crimes. So since 2014, we started to have, and it was just right before the beginning of car wash operation in Brazil, we started to have the possibility, considering crimes in organized crimes, just for organized crimes, a kind of a collaboration, a proposal of a collaboration with the reduction of the penalty. So it was probably the base of the car wash operation. And we are not talking here about inquisitorial or adversarial, because apparently or officially we have changed. We are still a civil law country, and we have changed from a inquisitorial to adversarial. Although we are talking about this changing, and this is an example, we are changing the system, but although we are still a civil law country, we don't have discovery, we don't have a lot of process before the trial. We don't have these all pre-trial situations that you face in US. But although we had this law changing everything and proposing for organized crimes, the possibility for this collaboration. So it was a lot of standards of before conditions to have this deal, to cut this deal. We had a lot of conditions before, so you have to confess, you have to pay everything that has been some kind of, if you're talking about a corruption, for example, the product of the crime, so you have to pay it back, and then you have to deliver, and you have to inform, because it is a collaboration after all. So you have to, the defendant represented by his lawyer has to demonstrate and to collaborate to show the other partners and everything else, and the whole scheme, the criminal scheme, that it's been involved on this collaboration. So I think that all of us and all of you here, you saw what happened in 2014, 15, 16 in car wash operation, that we have a massive attack using these collaboration agreements. But we didn't change anything related to our procedure, criminal procedure. So our code is the same. It's a civil law country. So we still have the police investigating, being led by the prosecutor, and we couldn't face any kind of changing while after the indictment. We couldn't see any kind of distinction, and that could put this judge in a position that it's separated from the parties, right? So I think that you all know also the critics that Judge Moro is facing because of this difficulty to put the judge in a position that it's the same position that it's independent from the parties. So this is an example of what happened in Brazil. So you change an institution, you create a kind of a collaboration agreement, but you don't change the whole proceeding. So you just create an institution here, the institute here, the concept here, you change the whole system, but without changing the other part. So, and after that, in 2000, when Judge Moro, who was the Minister of Justice in Brazil, he proposed another change. And now we have a different, now we properly can say that we have a plea bargaining in Brazil, because different from the collaboration agreement, you just have to plead guilty. You don't have anymore to be a collaborator itself. So, so now after 2018, beginning in 2019, we have this a non-prosecution agreement, but for individuals, not that like an NPA, a DPA, because it's not for companies, it's for individuals. So you can have actually a plea bargaining in Brazil. So it's for some crimes. There are some exceptions, for example, domestic violence or things that it is not included. But most of the crimes, including corruption, money laundering, and so most of the crimes, they are included on the possibility to have this plea guilty, this plea bargaining, this kind of agreement. But again, what we are seeing is we have these without the changing of the other proceeding, the regular one. So you don't know exactly what the conditions are. And just like what Marco was saying, that in the other countries in Latin America is happening, in Brazil also with our new constitution in 1988, the prosecutors, they gained much more power here, and this plea bargaining system now it's a way to prove that they have a lot of power. They are substituting judges in some situations, deciding for themselves as what to propose, when to propose the agreement, or when not to propose the agreement and to indict. But I think that we are adjusting to all of this. But what I can say to you is that we have everything now. Now we have plea agreements. Now we have non-prosecution agreements. Now we have grand jury here. It's a very small, it's a very few cases that are subject to grand juries here. Just crimes that involves, that attempt to life. So it's like murder, abortion, and the grand jury here is not different from what I was understanding from what Dan said. We don't have the grand juries here to investigate the case or to decide whether to indict or not to indict. This comes exclusively from the prosecutor. So the decision to indict or not to indict comes exclusively from the prosecutor. And then with these exceptions, it's every time it's a single judge that decides whether to convict or not after the indictment, after the proofs, that the evidence is to be produced. But in crimes that involves the attempts to life, so it's like homicide, murder, abortion, and attempt to suicide. So these crimes, we have a grand jury with 7 jurors that vote yes or no, coordinated by a judge. So we have this exception here, but not to investigate, just for the final decision. After everything has been investigated, so the prosecutor comes asking for conviction, for example, and the defense lawyer will sustain that it has to be acquitted, for example. So it's like, it's a few amount of cases, it's a few bunch of cases, because not that we don't have a lot of murders, we do have, but compared to the theft, track questions and corruption and all the other cases we are talking about, a few cases, a few possibilities for the grand jury. So to tell you what I can think about what I've heard from my colleagues here is that Brazil, we have everything. We have everything that you want. If you want to ask me if you have grand juries, yes, we do have. If you want to ask me if we have jury trials, yes, we do have. For some cases, if you have non-prosecution, yes, deferred prosecution, yes. The problem is that they are not coordinated between themselves. So you keep like fighting and to seize or to fit the case in the situation that it's more like it's possible, considering if you are either a prosecutor, so try to accuse, or if you are trying to defend and to navigate into this bunch of possible situations that our law offers to you. So I don't know if I could make myself clear, but I think this is a mess, and this is how Brazil is.
Thank you, Ludmila. It looks like Brazil has made decisions to take bits and pieces and of certain aspects of criminal practice and apply it to their system. And at least in the car wash case, certainly the introduction of plea bargaining has made a monumental difference in pursuing that case. So it's very interesting. It's a very direct and practical.
Yeah, it's a learning process, right? So we are learning. I think that we are going to have things and cases that are going to be annulled. We are seeing these happening now, but it's like it's a pendulum, right? So we come from one to another until we find some place in the middle.
All right, so thank you, Ludmila. I'm now going to turn it over to Andres. And to Andres, as I mentioned before, I was actually surprised to learn that Argentina has had jury trials, full jury trials for now over a decade, if I'm not mistaken. Can you explain that process? I know that you've been involved in the process of moving these reforms forward to create the possibility of having jury trials. Can you discuss why Argentina decided to go with jury trials? And can you explain some of the basics? How many members of a jury are there? Does it have to be a unanimous decision to find somebody guilty? Just whatever aspects you would like to discuss. And I think this will open up really, hopefully, a lot of opportunity for others to comment based on their own experiences as well. We have a little bit over 20 minutes left, but if you want to maybe, however time, 10 minutes, and then maybe others can comment on Andres's exposition or his discussion of jury trials in Argentina. Thank you.
Hey, thank you very much, Andres, for your introduction, and thank you so much to Professor Langer for inviting me to this nice conversation. I'm really enjoying it. I'm learning a lot. And okay, I'll try to be brief. Argentina started with juries in 2005 in the province of Córdoba with a mixed court with 8 jurors and 2 judges deliberating together, just like the European jury, as we can say. But the model that finally got implemented in Argentina since 2011 until now, in at least 10 provinces, is the American jury. A jury of 12 with gender parity is mandatory. Our juries have 6 men and 6 women ordered by law. And in some provinces, like Chaco, Neuquén, Patagonia, or Chubut in Rio Negro, where there's a very big, huge population of indigenous people, the jury must be integrated with indigenous people. 6 indigenous people or 12. That depends on if the victim and the defendant belongs to the same nation. And so these are the distinguished features for the Argentine jury as to the American jury. But we have, a jury of 12 people conducted by a judge, presided over by a judge, who give the jury instructions on the law. We departed from the British and Canadian system, where the judge can make a summing up and discuss the evidence to the jurors or comment the evidence. We didn't want to give so much power to the judge, so we prefer the American model. And there's a voir dire with peremptories and challenges for costs. Only 4 peremptories are allowed in Argentina in every jurisdiction. And the first jury trial experience in the province of Neuquén started with, a verdict of 8-4. Then the province of Buenos Aires, the largest province in the country, moved to a supermajority verdict of 12-10, but unanimous verdict for, capital crimes. But from now on, all the provinces in Argentina requires unanimity to acquit or to declare some, or to convict. And so you asked me how juries are selected. They are extracted from the voting list. In Argentina, the voting is mandatory, so everybody is represented in the voting list. So there's, the jurors are extracted from that list and then go to a voir dire, to a venire, and then in a voir dire hearing. And you also asked me who has the burden of proof and the standard of proof. It's the same as in the United States. The burden of proof relies on the prosecution. The defendant has to prove nothing. And the standard of proof, and we put the reasonable doubt standard in every Argentine law. That was a major change. That is a major change, because for the first time, I think in a criminal procedure in Argentina, we stick now to a very precise standard of evidence. And the defendant has the right to remain silent, just like in the United States. And okay, but it's different, because if he decided to get to stand, and he's not a witness. In the United States, he's just like a witness, and he can lie and he can be cross-examined by the prosecution. In Argentina, okay, you have the right to remain silent, and also you have the right to not to testify as a witness. Huh? That's the only difference. But okay, so now we have 9 provinces today. Today's Tuesday in Argentina, we have for the first time simultaneously 7 jury trials in each jurisdiction, in Mendoza, in Chaco, in Entre Rios. That's something very important to us, because from the 2014, when the whole system started until now, there are, I think, more than 500 or 600 jury trials. And they were a complete success, because that's the main thing. And let me tell you one thing also, the verdict of a jury is final, just like in the United States. And that's also a major change, because in all the Latin American countries, and even the continental European countries, the verdicts are not final. A prosecutor can appeal an acquittal. And, and in Argentina, I think it's the first time, I'm not sure whether any other Latin American countries has the same law, but now we have the 2 systems. If we have bench trials, the prosecutor can appeal the not guilty verdict of the bench trial, of the bench judges. But if we have a jury trial, okay, the verdict is final, and everybody is accepting that. I don't know why, because many prosecutors and private prosecutors, because we have the figure of private prosecutors, have challenged this and said, okay, this is unconstitutional. Why? This is not fair. If the defendant can appeal a verdict, I can do it too. And to my astonishment, the Supreme Court and the Court of Appeals have said, no, this law is constitutional, but not because of a double jeopardy issue, but because the jury is the people. Because the jury is, the sovereign people. And so I think that, okay, whatever the reasons, I think that trial by jury in Argentina is now the most successful legal transplant in Latin America, I think, and even Europe, because I think the only model that can, okay, have this characteristic is the Republic of Georgia in Europe, but the jury in Spain, the jury in many other European countries, or even Russia, I think that they are not strong as it is now in Argentina. So I think we are witnessing a major change, because what are the consequences now of this? To my also, to my surprise, suppression evidence begin to flourish. And so the litigators, you know, the prosecutor and the defense attorney, they are more careful about the evidence. They are discussing the evidence in pretrial hearings much more than ever. And I think, and also the investigation process is being also affected and influenced by the threat of going to a jury trial. So now prosecutors are thinking, okay, this is a murder, this is murder, this is a very serious sex crime. I have to go to a jury. So that's another thing, because I have to gather more evidence. And so I think that in the future, and I was really interested by what Dan said, and I think that, and Ludmila said about the, I think that we are thinking very seriously of implementing grand juries in the, but first we have to consolidate the jury system. But I think that the grand jury is, okay, we all know that it's the shield and sword of the people, and because it can check, it's a check to the prosecution, because in Argentina, unfortunately, we still have, you, the Americans said, overzealous prosecutors. Okay, I say corrupt prosecutors who frame people, who frame investigations. And so I would love them to go to a grand jury and say, okay, do you have probable cause? Prove your case. Okay, show your evidence to a grand jury. But also there we have very brave prosecutors that have to go after blue-collar criminals, they're very powerful criminal organizations, and I think that the grand jury would be a lot of help. So this is, okay, what I have to say. I don't know if I'm right on time to speak about the, okay, the how jury trials are flourishing now in Argentina. So
That's
thank you very much, very much.
That's fantastic, Andres. It's fascinating. And I have a question for you, but I don't know if there's anybody else in the panel who would like to, who has a question maybe for Andres or for anybody else.
I mean, Andres, it's up to you completely, but if you want, I can do a round, you know, of comments if that it was in your initial plan, but I am also happy to follow the, to continue the conversation, specific questions, or if people have questions from the audience, right? Also,
Sure.
whatever you prefer.
I think summary remarks would be fantastic. At the end, Maximo, would be very welcome. Dan, did you have something, or did you have a comment or question?
Yeah, I've always been skeptical of this Argentine, defendant has a right to lie thing, which is essentially what I think Andres was saying in a more delicate way. But as a general matter, so two questions. One is, if the defendant does decide to testify, does the prosecutor have the right to cross-examine extensively and fully? And second, is cross-examination routine for every witness, and are the lawyers really getting into it? Is it developed like it is in the United States?
Okay, that's a very good question, because the jury trial bills, we use the jury trial bills to smuggle many other things. For instance, the reasonable doubt standard and the adversarial litigation techniques. You know, Maximo described this very well. We are if you come to Argentina, you are going to see written procedures everywhere in civil trials or in civil procedures. And so we didn't have at least the idea of what a cross-examination was. So, but since maybe 15 years from now, we started training lawyers, training students, training judges in litigation techniques. And so now we don't have rules of evidence. We have very little rules of evidence. And you know that all these litigation techniques rely heavily on that. But now let me tell you that in these fields, we have let's say a very if you come here to litigate a case, you will find yourself comfortable, with a direct examination with a cross-examination, then the redirects, and then the objections to the judge, etc. So if the defendant decides to testify, he can be cross-examined by the prosecutor freely. And but there's something that the prosecutor cannot do, even if the defendant testify, is to ask him about his prior convictions. He can't do that.
And he can't prosecute him for perjury in a subsequent proceeding, right?
Yeah.
No. The thing is, the thing is, there are several things there. I mean, elaborating further on what Andres just said. First, this is not a Latin American thing. It's a civil law thing, meaning that in Germany, in France, in Spain, I mean, all over Europe, continental Europe, defendants do not testify under oath, period. And this is where, this right to lie, right? Or at least this privilege to lie comes from, if you want, right? But this is, again, not a Latin American thing. It's just a civil law thing. Second, Argentina, it's a federal system. So essentially we have 25 criminal procedure codes, right? One per province, the federal one, the city of Buenos Aires one, right? And there is also another national one, whatever. So the rules for interrogation of witnesses will vary from place to place. There are a number of these more adversarial codes that have direct and cross-examination as a way to interrogate witnesses. Typically, though, unlike the US, if a defendant, let's say, decides to start testifying and then wants to stop when the prosecutor is going to cross-examine him, he can, with no legal consequences against him. So, I think that was your question, really, Dan. Yeah. And that's in that sense, there is not a full prosecutorial right to cross-examination like we have in the US, even with precedents by the US Supreme Court, right? In that direction.
But jurors don't like that. Yeah, Maximo is right. But whenever you are in front of a jury trial and the defendant said, "I'm not going to answer to that question," the jurors look to each other saying, "Oh no." So I think that prevents the defendant to do that. So it's a practical consequence.
But also in Mexico, sorry to chime in, but also in Mexico, there's a constitutional sense to it as well, that you cannot be forced to incriminate yourself, but you don't have to plead the fifth. You can lie if you want, because you don't have to incriminate yourself. But to say that you don't want to answer because you would incriminate yourself is incriminating in itself. So why would you say that?
So on a different topic, I thought a comment that I might make, having heard these fantastic comparisons and presentations, is remember I talked about formalism at the beginning and how our system is just less formal in what the prosecutor does. I hear a lot of, if a complaint is filed, then there's an investigation, or the jury has to be, if the complainant's from one tribe and the defendant's from another tribe, it has to be, balanced. There's not a lot of sense, and I know this exists down there, of the crime that's investigated on the initiative of the prosecutor. I think some countries called it the oficio, but it's not, as I understand it, not that common down there. And it's very common in the United States. Really, prosecutors are always thinking to themselves, there are corrupt politicians, there are corrupt police officers. Andres, if there are corrupt prosecutors in Argentina, there are corrupt whatever, and we're going to make it our business to figure out where they are. How are we going to get the lead to find that out? Where are we? Let's find informants, or look at SARS from the banks, or a whole number of other things. Or you're talking about the plea bargaining for cooperation. I'm familiar with the Argentina law. If I file an indictment against a lawyer for a serious tax evasion case, I don't just want to know who helped him with the tax evasion. I want to know what judges he's paying. I want to know what frauds he's committing. And in the United States, that's what we do. I used to ask every single person that sat in my office, I'm sure Andres Torres does it too, tell me about other stuff. Don't just tell me about your drugs. Tell me about political corruption in Manhattan. And that is it's a mindset that we have. And one last thing I'll say is, Ilan, I know you were nodding your head that you have the oficio, But I did a study. I was hired by one of the Mexican states to look into the top to bottom, the criminal justice system. And most of the prosecutors I interviewed and agents that I interviewed didn't know they had that authority. They thought that they had to wait for a complaint to walk through the door. Well, folks, if a judge is taking bribes, it's very unlikely that a complaint is going to walk through the door. Or if a mafia chief is extorting all the local businesses, that complaint's not going to walk through the door. So that's a huge, I think it's a huge practical difference that doesn't have to be necessarily. So I throw that out, sorry, in the last few minutes.
Marco, I don't know if you are answering that question. I'm happy to,
It's a comment, but I'd love to hear your.
But I totally, but I'm happy to engage with it. But Marco, I'm not sure if you want to.
Just a few. Thank you. Just a few words.
You have a total of 4 minutes. So
yes, very fast. In Latin America, most of the legal system has give the ability to the prosecutor to start their own investigation, so they can do the same thing that you are doing in US. The thing is that because of implementation problem, practical issues, and because they are full of work, they don't want to open generally. They don't want to open new cases, and they're just opening and dealing with the criminal complaint that is provided with from the police. And this is the main problem fighting organized crime, because in organized crime, we don't have a victim giving a complaint to the police station of drug trafficking or human trafficking or child pornography and another kind of crime. So the main challenge in the region is that they have the law, but they are not using that law to open their new investigation and to work with other agencies, with task forces. This is a main challenge in the region.
I think that the other thing there is that that in the American system, it's relatively easy, as Dan, you were mentioning, with grand jury investigations, but that also applies to police investigations or other law enforcement agencies. It's relatively easy to keep investigations open for a long time and informal, right? As long as no indictment is issued, no information before a magistrate or someone is arrested, right? Investigation can go on an informal basis for a long time, right? The speedy trial, time is not going to start ticking, right, etc. In Latin America, in most places, that's very hard to do. The courts have some period to do something like that, but they are very short periods of time. So I think it's very hard to do informal investigations, right? And that's a major challenge or maybe one of the major challenges to investigate some of the organized crime. On plea bargaining, there are 2 minutes left, but let me just say very quickly, we have to distinguish two things that in the American system are mixed. Because in the American system, most plea agreements are used not for organized crime, but for very ordinary crime, and it's a way to reach a criminal conviction. And then the same institution is used, or mechanism is used, to obtain information or testimony, right, from people, right, that then can be used and leveraged against other defendants, other people participating in the crime. In Latin America, typically we have two different institutions for that. And that's important to keep in mind. In Brazil, we only have the second. We don't have the first. There is not such a thing. There is no plea bargaining in the American sense. There is no way to reach a conviction without a trial in Brazil, even if we can also talk about how trials look like in Brazil for real, right? Which is something we could elaborate on. So in Argentina, the two exist, but they are two different institutions, right? And so anyway, that's a distinction that I think, at least from a legal perspective, is worth making.
Guys, we are at 8 o'clock. I would love for this conversation to go on, really, and I think that maybe we need to do a second panel, a continuation. It's really been fascinating. Thank you so much to everybody. I know you're different parts of the world and you had other commitments, so thank you so much for making the time. It's been a great discussion, and on behalf of the New York City Bar and the Inter-American Affairs Committee, I just want to again express my deepest gratitude to all of you for your time and for your participation. Thank you.
Thank you.
Thank you very much.
Stay safe, everyone.